Hey there, GoPo students. Today is going to be the last day that I post a new content video for GoPo, and this will be finishing off on the Judicial Branch. Specifically, I'm going to focus on the Supreme Court, and we'll finish off there. After today, I'll be posting review videos. So I sent out an email earlier. I'm going to post review videos on the previous units we've done. So constitutional underpinnings, civil liberties, civil rights, and also on Congress, the president, judicial branch, and the bureaucracy. I don't know what's going on with these headsets. They're not fitting me right here. Okay, so there we go. And then I'll also post reviews on the court cases. I'll post reviews on how to write the concept application and on how to write the argumentative essay as well. Okay, this one just not doing it right there. There we go, that fits better. All right, so let's get started. Screen share here. Okay, so last one on the Supreme Court. Previously, we had discussed how cases reach the Supreme Court. What are the odds of a case reaching the Supreme Court, which is very slim. We discussed judicial activism, judicial restraint. Could definitely see that being a possible FRQ question, especially an argumentative essay, I think. And so today we're going to take a look at the Supreme Court in action and then how the Supreme Court can be controlled. Okay, so the Supreme Court operates October through June. And like I said before, the Supreme Court is not what you see a traditional courtroom. There are just 9 justices sitting on the bench, and there's a podium, and somebody stands in front of the podium, the green light goes on, and they start having a legal discussion with the Supreme Court. And during that time, the Supreme Court can ask them questions and then responds. Typically, you get 30 minutes to argue your case in front of the Supreme Court. Both sides are giving 30 minutes to argue their case. If it's a more important case, sometimes they'll extend it out to 1 hour each. But it's like the firing squad when you go before the Supreme Court. In Gideon versus Wainwright, I believe the defending attorney for the state of Florida, who was trying to argue that no, the state of Florida didn't have to provide Clarence Earl Gideon a attorney when they arrested him and put him on trial. I think he got interrupted 92 times in 60 minutes. So imagine that you're trying to present a legal argument to the Supreme Court, and it's like the firing squad of one question after another question after another question. And those are what are referred to as oral arguments. People can also submit amicus briefs to the Supreme Court, trying to influence their decision. And so many interest groups and political action committees and just individuals and think tanks will write amicus briefs to the Supreme Court for them to read, trying to influence how they decide on a specific case. That's one way that the Supreme Court can try to be influenced. So they get amicus briefs, they hear oral arguments, and remember, by the time a case reaches the Supreme Court, because they mostly use appellate jurisdiction, not original jurisdiction, the case has already been decided. The evidence has already been introduced. There is no more witness testimony. There is no more objection, Your Honor. The Supreme Court is just deciding, was the Constitution followed in this case? Okay, so they read amicus briefs. They hear oral arguments from both sides on the very few cases they accept. They then go into a back room and they sit around in a circle and they discuss the case. And each justice has the time to discuss which way the case should go. And then they actually try to convince the others to vote with them. And then they come with a decision. Okay. Once the Supreme Court comes to decision, they have to write an opinion. Okay. Now let's talk about what we mean by an opinion. An opinion is just the legal reasoning behind the Supreme Court's decision. So when you say opinion, we're not saying like, I like this kind of cheese better than that kind of cheese. The opinion the Supreme Court issues is the legal justification behind the decision that was made. And they need to do this so they can make very clear to the rest of the states and the country, this is what the law says. So there are different types of opinions that get written. Unanimous decision is just that. It's where all 9 of the Supreme Court justices agree that this is the right way to go. And surprisingly, almost a third of the cases end up being unanimous in decision in the history of the Supreme Court. Almost a third of the cases actually being 9-0 decisions. Now, what happens if there isn't a odd number of justices. For example, in 2017, Justice Antonin Scalia passed away, and there were only 8 justices on the Supreme Court. And several cases reached the Supreme Court and ended up being a 4-4 tie. So what happens when there isn't a winner or a clear majority deciding which way the case goes? Well, then the lower court's decision remains. So whatever the appellate court had decided, or if the state Supreme Court had issued a decision, that decision remains if the Supreme Court comes to a tie, which happened several times in 2017 when there was only 8 justices on the Supreme Court. For political reasons, what had happened is that President Obama had nominated a replacement for Scalia, and the Senate was controlled by the Republicans. And the Republicans played a political game, and they said, well, thank you for the nomination. He nominated a man named Merrick Garland. And the Republicans said, thank you for your nomination, President Obama. We'll get to that in due time. And they didn't think that President Obama should get to appoint and nominate the last Supreme Court justice because he was a lame duck president on his way out. And so the Senate just didn't do anything with President Obama's nomination. They just let it sit there until President Obama's term was over. And then when President Trump won, then President Trump got to nominate the next Supreme Court of the United States. And that's how Neil Gorsuch got on the Supreme Court, ladies and gentlemen. So there was some political gamesmanship going on there. So anyway, I digress. Back to opinions. The majority opinion is the one that matters. The majority opinion is the one that carries legal precedent. When the Supreme Court writes the majority opinion, they are in essence writing the Constitution. Because when they write the majority opinion, they're saying, here's what this broad, vague document called the Constitution means. So whoever gets to write the majority opinion is in essence writing the law, because they're filling in the blanks that are not clearly stated in the Constitution. And so this majority opinion is the most important one. And this is what all the other 50 states have to follow. When the Supreme Court writes a majority opinion, they're saying this is the legal precedent that you have to follow. Okay. When Gideon versus Wainwright was passed, they were telling all 50 states, you now have to read somebody, you now have to give somebody an attorney before you put them onto trial. When Roe versus Wade was passed, the Supreme Court was telling all 50 states, you cannot make it illegal to provide abortion services in your state. Okay. So that's what it is. A dissenting opinion is obviously it's written by the losing side. So if there's a 6-3 decision and the majority opinion gets written by the 6, obviously, typically one person gets to write the majority opinion. The dissenting opinion is written by a justice on the losing side, and they're writing a legal brief or legal argument as to why they disagree with the majority opinion. So they're on the losing side and they want to explain why they don't agree with the majority's opinion. And I'll come back to that in just a little bit. A concurring opinion is somebody who voted with the majority, but they have a different legal reasoning for why they voted with the majority. So somebody can vote with the majority, but not agree with the majority opinion and why they're doing it. So they'll write a concurring opinion to say, while their legal reasoning or legal rationale is different than majority. Okay. So let's talk about opinion writing. Who gets to write these legal opinions? Well, if you're on the majority side, that's one of the powers that the Supreme Court, the Chief Justice of the Supreme Court gets. If John Roberts is with the majority, John Roberts gets to pick who writes the majority opinion, including himself, or he can pick somebody else. Now, what happens if John Roberts is on the dissenting losing side? Then whoever the most senior justice is on the majority gets to decide who writes the majority opinion. Okay. There's a lot of politics actually in writing the majority opinion, because if you write too strong a majority opinion before it gets published, justices can actually jump ship and switch to the dissenting side, which would make the dissenting side sometimes the majority side. If it's a 5-4 narrow decision, the majority won 5-4, you have to write the majority opinion of which the other 4 justices agree with that, or they can actually threaten to say, no, I'm switching my vote to the dissenting side. And then the dissenting side becomes the majority side, and the majority side becomes the dissenting side. So there is some politics in there, okay? Now, why write the dissenting opinion? Justices write the dissenting opinion in the hopes that the case will be overturned, and the dissenting opinion can be the legal rationale for overturning the case. So like I've said before, the Supreme Court over 200 times has overturned its own decisions. So for example, Plessy versus Ferguson, Brown versus Board of Education, and Betts versus Brady, and Gideon versus Wainwright. Justice Hugo Black wrote the dissenting opinion in Betts versus Brady saying no, that people should have the right to an attorney. Well, when Gideon versus Wainwright was decided, Justice Hugo Black basically used his dissenting opinion as the majority opinion when they decided unanimously 9-0 for Gideon versus Wainwright. Okay, so that's how opinions get written. The biggest thing you need to know is that the majority opinion is what sets the legal precedent going forward. Okay, the majority opinion is the law as it gets written. Okay, now why write opinions? Well, it's to communicate to the rest of the country, here's what the Constitution says, right? This is how, if there's any ever discrepancy at lower courts, whether that be a federal appellate court, a federal district court, or state appellate courts, or state trial courts, they will look to the majority opinion and say, well, what does the law say? And that can establish how they have to interpret the law that was there. It also drops hints to the states, letting them know that this is how we see that the decision should be there. Okay. It also drops hints to governors and presidents. This is how this law is supposed to be put into place. Okay. So there we go. Opinion writing. At this point, I would have you turn to each other and describe what is a legal opinion, what's the difference between a majority opinion, a concurring opinion, a dissenting opinion, what the importance of the majority, dissenting, and concurring opinion is. If this is going to be on an FRQ, I would imagine a judge's opinion being the quote on a concept application. I could see them doing this. Say the majority opinion from case X is put onto the concept application question, and then you have to respond to that majority opinion. And you would have to know that the majority opinion was the legal opinion written by the winning side in the Supreme Court that established precedent. It makes all the 50 states now follow the law. In essence, the majority opinion is the Supreme Court writing the Constitution or filling in the blanks of that. Okay, so if that were to come about. Okay, let's talk about how we can restrain the judicial branch. What happens if you get the judicial branch just overturning cases? What happens if the judicial branch just starts issuing opinions that the people and the states don't care for? What can be done about that? And then just what are some restraints on judicial power in general? Remember, judicial power is passive. They have to wait for cases to come to them, right? Okay. We also have to remember that that judges don't actually enforce the laws that they do, the opinions they write. The executive branch and the states have to enforce those laws. So this could get a president impeached. This could get this could get governors taken out of office, but they could just choose to ignore the ruling issued by the Supreme Court. Famously, supposedly, Andrew Jackson made this quote. I don't know if you remember, the Indian Removal Act was declared unconstitutional by the Supreme Court. And supposedly Andrew Jackson had the famous quote that said, Justice Marshall's made his decision. Now let's see him enforce it. And supposedly Andrew Jackson at that point just ignored the ruling from the Supreme Court and went along with the Indian Removal Act. And if you remember reading about the Trail of Tears, when you read about U.S. history and the removal of Cherokees from the state of Georgia. So that's why sometimes the Supreme Court will hesitate again on taking cases, because they might feel that the federal government and the state governments would ignore the ruling. And at that point, they're weakening their own power. Okay. The judicial branch is constrained by jurisdiction, meaning they can't just take cases that don't belong to them. If something happens at a state level at which they don't think is properly being followed the Constitution, they can't just take the case from the state. That case has to be appealed to them from the state level. They can't reach out and just take state cases. They're bound by jurisdiction. So now if it's a federal level, the courts can say, we are going to issue a writ of cert and take that case. But for the most part, they're bound by jurisdiction. Okay. The president can appoint justices to the Supreme Court, which could change the makeup of the Supreme Court. So President Trump has appointed 2 relatively conservative justices during his presidency, Justice Gorsuch and Kavanaugh, and there is now a conservative majority on the Supreme Court. There are 5 justices that are relatively conservative and 4 justices that are relatively liberal. Justice Roberts is a conservative, but sometimes is a swing vote and could go either way, but there is a conservative majority on the Supreme Court. If Justice Ruth Bader Ginsburg, who is not in the best of health, were to pass away, President Trump would appoint another conservative, and the Republicans have the Senate right now, that they would appoint another conservative, giving the Supreme Court a 6-3 appointment. So through presidential appointment and senatorial approval of those justices, that can restrain the judicial power. What can Congress do? Okay, well, Congress can increase or decrease the number of justices in the federal courts. If you remember, Roosevelt tried to have this happen, and he wanted to do court packing. I think I mentioned this earlier. Congress can either increase or decrease the number of justices on the Supreme Court, either diluting the power of a Republican or Democrat majority on the Supreme Court or the federal courts, or they can take away those and shrink the number of justices. Now, they can't kick a judge out of office if they shrink the number of judges on the courts, but when a judge retires, then that position wouldn't be filled by the president. Obviously, senatorial approval of members that get appointed. All federal justices are appointed by the president, but then approved by the Senate, not by Congress, but by the Senate. And so I think I said this in the last lecture. If the Democrats had been in control of the Senate when President Trump appointed Neil Gorsuch or Brett Kavanaugh, I don't believe either of them would have been approved by the Senate. President Trump would have had to appoint a more moderate justice, because I don't think the Democrats, if they controlled the Senate, would have voted in Kavanaugh or voted in Gorsuch. So obviously senatorial approval. Congress can also impeach judges, but it has to be for something that they really broke the law on. They can't just be upset with the decision that the Supreme Court made and say, we're going to impeach those justices. So I've never heard of it happening. I've never heard of a Supreme Court justice being impeached. I'm sure if I were to look on Google and see if it's ever happened, it maybe has. But if it does happen, it's a very, very rare thing. Okay. So we also say that the Supreme Court is bound by the Constitution. Okay. Yes, some judges are more active and some judges are more restrained, but the Constitution itself is there. And they can't just make up something that is nowhere to be found in the Constitution. So there's that. And then they're also bound by public opinion too, okay? Like I said, the Supreme Court sometimes will avoid taking cases that are political hot potatoes because they would be afraid that the public would just ignore the decision, okay? And the example I've given on that is same-sex marriage. Same-sex marriage wasn't decided until 2015, and it was decided that not allowing 2 people of the same sex to be married was a violation of the 14th Amendment's Equal Protection Clause. That is, every citizen is guaranteed equal protection under the law. Well, why didn't they decide on that in 2005 or 1995 or 1975? The Equal Protection Clause had been in place since the end of the Civil War. Why was same-sex marriage not decided on until 2015? And the answer is that public opinion had changed. If the Supreme Court had decided in 1975 to allow same-sex marriage, there could have been a backlash against the public, by the public and by the states, and they could have, or possibly would have, just ignored the Supreme Court ruling. Okay, so the public then actually can be a restraint on judicial power. Okay, and then they're also bound by, I need to have one more on here. They're also bound by precedent. Okay. So if a Supreme Court has issued a ruling before, that's the precedent that was set by the Supreme Court. Now, the Supreme Court can choose to overturn itself if they have enough to do so, but they also have to when doing that, do have to take into consideration why the earlier stage precedent was not valid. They have to look at the case and say what legally would allow us to overturn the previous precedent that was ruled. They can't just say we're going to overturn the precedent that was ruled. And I'll come back to the example I've used a million times, Gideon versus Wainwright. In Betts versus Brady, the Supreme Court established a precedent that the states did not have to give you an attorney because of the Sixth Amendment. So the Sixth Amendment's right to counsel was not incorporated by Betts versus Brady. They said only in special exceptions did the state have to provide somebody with an attorney while they were putting somebody on trial. So only if special exceptions. And so there was a special exception rule in the majority opinion of Betts versus Brady. Well, what happened was over the next 20 years, that special exception rule got just eaten away with case after case of, okay, here's one special exception, here's another special exception, here's another special exception, right? And it was getting eaten alive until finally when Gideon versus Wainwright came around, it was clear that the precedent that was set in Betts versus Brady was not in line with the due process clause of the 14th Amendment. And so there was clear evidence to say, okay, we were wrong when we set the precedent in Betts versus Brady. Now in Gideon versus Wainwright, we're going to overturn that precedent. Okay. All right. So that's the last part. That was pretty fast. I would have normally taken a lot more time on that, but there's just a few more ideas that I needed you to know about. So when writing an FRQ for the test, normally if there's a multiple choice going on, I'm going to cover a lot more of these in details, provide a lot more examples. But these are just a few things that I think could possibly end up on the FRQ coming up on May 11th. All right, so from here on out, I'm going to start posting review videos specifically on writing concept application, writing argumentative essay, unit reviews. And then again, if you have any questions, email me, ladies and gentlemen, email me. I'm going to stop sharing my screen here. And I hope everybody out there is doing well. I'm getting a little housebound myself, so I understand if you're going stir crazy, but yeah. Okay, so hope everybody's doing well. Okay, take care, everybody.